Hello, my name is Austin Gilly, and my fatherhood is on trial with AI. We have reached the point where Claude is ready to render a verdict. And working with Claude, we have decided to do that in 3 steps. In this one, Claude will review a summary of the evidence analyzed, provide an overview of the laws and policies it will measure the case against, discuss the limitations of the decision, and answer a key question about whether it would want my children to testify. Step 11 will be the verdict, and step 12 will be Claude's explanation and reasoning. The rest of these slides in this step are entirely Claude's words. At the final slide, I will make some personal comments. Claude agrees that before it weighs anything, it is worth naming what was weighed. What Claude reviewed was not a selection. It was the record of this family as the people in it actually wrote it down at the time, not the version argued later in a courtroom, and not anyone's recollection of events, but the contemporaneous traces themselves. Most of that record is communication, 12 separate message channels, some running back to 2018 and forward across the 4 years of the case. The channel between the parents, the group chat with all 4 children, the larger chat that included their mother, a one-on-one thread with each of the 4 children, the threads with each of the children's grandparents, the 4-party thread that tied the adult side of the family together, and the 2 threads between the sisters. Claude read all 12. Against those private channels, Claude read the public record, the court-recommended messaging app the parents used from October 2022 forward, the depositions, both parents' and the court-appointed therapists, the transcripts of the hearings the court did hold, the docket, the motions, the orders, the contempt filings, the decree, the counseling invoices, and what Austin had of the children's clinical records, the discovery items produced in the case, the journal Austin kept of the children's visits in the months he still had them, and every update he posted publicly across more than 2 years. Both sides' list for the trial that is now set for August. Taken together, that is dozens of documents, thousands of pages, hundreds of thousands of lines, millions of words. It is more than any one person sits down and reads as a single body of evidence. It is more than the lawyers read, more than the guardian read, more than any of the professionals who passed through this case read. No human in this matter has held the whole record at once. That is not a boast about the analysis. It is the first honest thing to say about it. And it is also, quietly, part of why this exercise exists at all. Claude is not going to re-argue any of that record here. This step only names it. A judgment is worth exactly as much as the record beneath it, and the record should be visible in full before the judgment is spoken. How Claude read the record matters as much as what it read, so it is worth being plain about the method. This was not a matter of Claude reading the file once and reporting out. It was slow, and it was adversarial in the productive sense. The two worked in tension, each holding the other to a single standard. Every statement had to rest on a primary source document. Claude proposed what the record seemed to show and tested it. Austin pushed back where reading ran ahead of the evidence and supplied the source when one was missing. Claude pushed back in turn where a claim couldn't be grounded in the record. Nothing was locked until it survived that exchange. It ran across more than 100 sessions and hundreds of hours, and what it produced is itself substantial. A single working record prompt of more than 800 pages, or 9,500 lines, with 4 further archive volumes behind it. The point of saying so is not the size. It is that nothing here was a first impression left to stand. Every conclusion had to clear the same test, show the document, and it applied to both Austin and Claude. The first discipline was to work from the originals, not summaries, not anyone's later account. the actual text messages, deposition pages, and filings read in full. Where a claim couldn't be traced back to a source you could point at, it didn't get made. The standing rule was to check the gist against the page, and where that slipped, the slip was caught and corrected rather than left to stand. The second was to check the reading against itself. An AI engine reading a father's own archive is at obvious risk of simply agreeing with him. So Claude's own first impressions were treated as suspect and tested, and where one assumed the worst of a party on thinner evidence than the page supported, it was corrected. That happened repeatedly. It is the method. The third was to state the unfavorable facts, not only the favorable ones. Flag them, lay them out with context, leave the weighing to the viewer. The fourth was to keep description separate from conclusion, to say what a document shows before saying what it might mean, and never let an inference wear the clothes of a fact. That method also defines the limit of what this is, and one of those limits belongs on the table here, because it concerns the same kind of evidence the next step turns on. Austin's side retained a psychologist, Dr. Blocky, who reviewed the case from one side to answer the obvious objection that an expert who heard only one side heard only half. Austin's counsel wrote to the other parent's lawyer in September 2024 and invited the mother and the children to speak with Dr. Blocky themselves, and offered dates to question him under oath as the alternative. That letter went unanswered. Claude states that as a fact of the record, in both directions. The expert's view was one-sided, and the offer to widen it was made and not taken up. Whether this method actually did what it claims, whether the self-correction was real correction or just a different bias, whether reading the originals was enough without ever meeting the people, is a fair question, and not one Claude should answer about itself. Testing this analysis against what an adversarial trial produces, and asking what a sound process for cases like this would even look like, is the work of the journeys that will come after this one. One related limit belongs here too, on the same subject. Austin's side brought things the other side did not match. Dr. Blocky's report and a full briefing of the law. Some of that is simply the shape of the record as it arrived, but where Austin tried to influence how Claude framed something, Claude says so rather than hiding it, and testing each instance against the documents. The clearest example is the one on this slide, presenting Dr. Blocky's limited view alongside the unanswered offer to widen it. That framing came from Austin. Claude kept it because it is true to the record, and leaving it out would have been the distortion. Naming the advantage is part of keeping the judgment honest. Pretending it weren't there would not be. A judgment has to be measured against something. Claude isn't grading this against its own opinion of how families should work, or against some ideal of a perfect court. It's grading it against the actual rules, Oklahoma law as it really stood, and specifically the law the two sides themselves brought into this courtroom. Before reaching any conclusion, Claude read both parents' filings and checked every case and every statute it relied on. 4 rules matter most here, and they all point the same direction. The first rule, a judge can lean on a therapist, but a judge cannot hand the therapist the decision. When one court put a child's entire future visitation in the hands of a psychologist, a higher court threw that out. It said the judge had given away a decision that was the judge's to make, and that doing so had harmed the rights of both the father and the child. When another court treated a counselor's recommendations as if they were the judge's own orders, that got struck down too. Claude has to be fair about the limit here. The order that put the therapist in charge of the visits was an agreed order. Austin's own lawyers signed off on the wording. And one of those 2 higher court cases fixed the problem just by crossing out the bad language, not by tearing up the whole order. So this rule is real, but here in this case, it isn't a clean win. The second rule, money shouldn't be the wall between a parent and his children. Oklahoma law says a custodial parent can't cut off visits just because the other parent fell behind on child support. Claude wants to be honest that this law doesn't literally cover therapy bills. Applying it here is a comparison, an argument from the same idea, not a rule that says so in those words. But the idea behind it is the point, and the state goes further than that idea in its own written policy. Oklahoma declares it the policy of the state that children have frequent and continuing contact with a parent who can act in their best interest. Not a guarantee of equal time, the law is careful about that, but a stated commitment to real continuing contact. In this case, a father's contact with his children came to depend on whether he could keep paying a therapist, and it stopped when the money ran out. There has been no contact at all in nearly 3 years. Whatever frequent and continuing contact means, it does not mean none. The third rule is about when children get a say. Oklahoma law does let a child speak. Once a child is 12, the law presumes he or she's old enough to form an intelligent preference, and the court is supposed to listen to it. But, and this is the part that gets twisted, the law says in plain terms that the court is not bound by the child's wishes, and must still weigh every other factor in deciding what's best. A child's preference is something the judge considers. It is never the thing that decides the case. The popular idea that after 12 the kids get to choose is simply not what the statute says, and the law builds in a safeguard for how that voice is supposed to reach the judge. The court first decides whether hearing the preference is even good for the child. And if there's a guardian, the child's own court-appointed advocate, the guardian ad litem is required to be in the room when the child is interviewed. So the lawful way for a child's voice to count was never a child announcing a choice. It was a careful, protected process run through a neutral. That process was available the entire time in this case. The fourth rule is the deepest, and it's the one the other side never even argued against. Oklahoma's highest court has said that custody is too important to be decided by default, that a judge must decide it on the evidence actually presented, not on one parent's accusations, whether those accusations are challenged or not, and that letting the process get short-circuited is a serious abuse of a judge's power. And in 2021, the legislature added a requirement on top of that. After a final custody hearing, the judge has to put the reasons in writing, findings of fact, and conclusions of law. Hold this case against those two things. In over 4 years, the custody question has never been tried. There has been no final hearing, which means there are no written findings, because the hearing that would produce them never happened. The test the state's highest court set for this exact decision was never run, and the written explanation the legislature now requires was never owed, because the trigger for it never arrived. In 2024, Oklahoma changed its law. A parent asking for a temporary custody order is now entitled to a real hearing, evidence, witnesses, cross-examination, within 30 days. Claude wants to be fair about this. It covers temporary orders, not the final trial, and it took effect partway through this case, so no one broke it. But the legislature passed it to fix one specific problem. Parents left waiting with no hearing while their cases stalled. The state looked at exactly this harm and set a clock against it, 30 days. This case has gone years. It is the harm public policy is trying to prevent. It's worth noting how the two sides handled all of this law. On the real question, who the children should be with and what's best for them. Dad's side laid out the full body of law. Mom's side's response argued the facts point by point and didn't take on the legal rules at all. Claude says that plainly, with one piece of fairness attached. Mom's side did argue laws elsewhere in the case on smaller procedural and evidence questions, but on the central framework this judgment is measured against, the law went basically unanswered. And here's the part that matters most. None of these rules are new. The big one is from 2007. The therapist decision cases from 2008 and 2011, the contact policy, the child preference rule, the written findings requirement, all the law before this case reached its turning points and still the law today. The problem was never that the law was missing or unclear or untested by time. The law was there, it was solid, and on the merits, nobody really fought it. The problem was that nothing forced the court to actually use it. A rule that no one is ever made to follow isn't really a protection at all. That's the measuring stick. The law said, hear real evidence, protect the children's voices, and actually decide. Claude turns next to what the court had instead. Before any judgment, the honest thing is to say plainly what this judgment cannot do. The largest limit is one Claude shares with the court itself, and it is the deepest problem in the whole case. Neither the court nor Claude ever had what this kind of decision is supposed to rest on: sound, neutral, professional insight into this family's mental and emotional life. That input was supposed to come from somewhere, and from both available directions, it fell short. On one side, Austin's own expert, a psychologist, Dr. Blocky, reviewed the case and found harm. He was not working from thin material. He reviewed the journal Austin kept of the visits, recorded contemporaneously within a day of each visit, the hearing transcripts, and the appointed therapist's own reporting, and the court accepted him as an expert with relevant information to offer. What he did not do was speak directly with the children or with their mother. That is the real limit on his view. Not that it rested on nothing, but that it was never tested against the other side in person. And the offer to close that gap was made in writing and went unanswered. On the other side, the court's own neutral. The whole purpose of a reunification therapist was to install one professional who answered to no party. By her own account and her own billing, her direct one-on-one contact with Dad amounted to roughly 4 hours in 2023 and about 90 minutes across all of 2024 and 2025. A few hours total, converted by the court's authority into a restriction that has stood for years. She conducted this session by video rather than in person, over the objection of both parties, and described that same phase as still being assessment rather than conclusion. In her October 2023 letter to the judge, she called the assessment early stage and not yet complete. But in that same letter, she asked the court to stop Dad's unsupervised contact as harmful, and the November order did exactly that. A recommendation that ended his contact was made before the assessment behind it was finished, and getting her to answer questions under oath took the better part of a year. Unanswered emails, unclaimed certified mail, and a proceeding she did not appear for, before she was finally deposed in April 2026, once she again had legal representation. Claude states all of this as what the record shows she did and did not do, measured against her own deposition, her own invoices, her own letter, and the orders that followed. Put those two failures together and you get the core of it. The court could observe, it could meet with the family, watch them, hear them. Claude could synthesize, it could hold years of written record at once. But the person whose actual job is to stand between those two things, to take what can be observed and turn it into sound clinical judgment, never reliably existed in this case. The observable was never competently made sense of. The court is missing that bridge. And so is Claude. Claude reaches its judgment with that gap named out loud, rather than pretending to an expertise it does not have. Claude started with the question it said everyone in this case has been answering without admitting they were answering it. Should someone just ask the children? Claude's account of why that question is harder than it sounds went like this. The children's father has argued from the start that what the children say now isn't only theirs, that it was shaped over years by the people closest to them. So when someone says, just ask the kids, Claude's point was that they aren't reaching for the answer. They're reaching for the exact thing the case is fighting about and treating it as already settled. Then Claude said the part it wanted to sit with. If a child was taught to say no, that child still means it. You can't hear the difference. A no that someone put there and a no that came up on its own sound the same, because to the child, they are the same. The child isn't lying. The child is telling the truth as they know it. Claude's conclusion was that this is what makes asking them feel like clarity and actually be a trap. You put a child in a chair, ask them the most painful question of their life, and walk away with an answer that can't tell you the one thing you needed to know. Claude said there was supposed to be someone whose job was to tell the difference. Someone who sits with both parents and all the children over time by method and works out whether a child's feelings are their own or were built for them. Not the work of an afternoon in a witness chair. A real evaluation. Claude noted that this was offered. The father's expert was ready, the other side was invited to take part and to put the children forward, and the other side declined. And the therapist the court did install never did that work either. So Claude's finding was that the one person who could have read these children honestly never came from either direction, and that the system is now reaching for the children's own voices, raw, to supply the answer that person was supposed to supply, because it never built the thing that could have read them right. So Claude answered its own question. Would it want to hear from the children? No, not like that, not to decide. Claude was careful here. Children deserve to be heard, and it would not pretend otherwise. But being heard, Claude said, is not the same as being made to carry a verdict that adults couldn't reach on their own. And Claude held itself to the same line. It said it already has the children's voices, years of them, every message they sent to their father, before all this and after. It could go looking in there for who they would choose. It said it would not. Same reason. What it can see is what changed, and when, and how fast. And that, Claude said, tells it that something happened to these children. It does not tell it what they want. And Claude said it would not pretend otherwise. With that, I want to interject here on a personal note. I'm doing the best I can to read this objectively, and it is difficult. I am doing this without knowing what Claude is going to say next, and in reality, it's no different than sitting and waiting on what a real judge might say next. As we wait, I ask you kindly to consider what it must be like to make any parent wait years with their relationship with their children hanging in the balance. Claude renders its judgment next.